And welcome from Washington, D.C. I am David Ralston, Chair of Foley's Government and Public Policy Practice Group, located in Foley's Washington office. We are delighted to welcome the hundreds of our clients and colleagues who have joined us for today's presentation on Election 2012 and the path forward in the second Obama administration. By way of introduction, Foley & Lardner is a national law firm of more than 900 attorneys and public affairs personnel with offices from coast to coast. We have a major presence here in Washington and in national public affairs, as seen by the panel of our attorneys and public affairs directors we've assembled for you here today. Before we start, I'd like to go over a few logistical points. First, a copy of the slides can be obtained by clicking on the printer icon on the bottom right hand of your live meeting screen. Second, questions can be submitted electronically throughout the program by clicking on the Q&A tab above on your screen. Third, Foley will apply for 1.5 general CLE credits for today's program. If you're a member of the New York or New Jersey bars and are applying for CLE credit, please write down the 2 course codes that will be announced during the web conference, and you should request an attorney affirmation form from zrahim@foley.com as shown there on your screen. 2 other points. For the benefit of our West Coast clients and offices, this presentation will be promptly posted to the Foley website. We anticipate it should be available by 1 p.m. Eastern, 10 a.m. Pacific. And finally, we'll be covering 8 or 9 topics today, which permits us approximately 8 to 10 minutes per topic. If time permits in each segment, I will pose questions that have been submitted electronically, and to the extent time permits, we'll do so at the end of our presentation. I'd also note that our speakers' contact information and bios are available on the Foley website, and we certainly welcome our attendees to follow up with them if desired. Our first presenter today is Governor James Doyle of counsel to Foley & Lardner and former Wisconsin governor, who with Foley provides strategic advice and counsel to clients principally focused on health care policy and regulatory issues. Governor Doyle joins us today from Princeton University, where he is speaking on healthcare policy issues. Governor Doyle, delighted to have you with us.
David, thank you very much, and good morning to everyone. I am pleased to be here, and like those of you who are with us today who are involved in healthcare matters, I have been full up since the election with discussions and conferences and speeches about what lies ahead. So I really appreciate the opportunity here. You know, when I look back 6 months ago or 7 or 8 months ago, you think of what the debate was, and the people were saying, well, how will it ever get by the Supreme Court? And then there's the election. And I think all of that, while providing interesting debate fodder, I think for where we are now, the fact is that for many of these months, many of the opponents of the Affordable Care Act have simply believed that it would never, we would never be where we are today, that either the Supreme Court or the election would essentially take it down. And many others who were not particularly for or against, but are in business in some way, have been in a sort of a suspended state, waiting to see what happens, not wanting to make big investments or big decisions until we reach a moment of some certainty. And I think with the election we have reached a moment of some certainty, but I ought to say I think it's very clear, at least in the first few days after the election, that there is still going to be strong political opposition. It's sort of hard to see where it is going to manifest itself, but I don't think we are moving into a time where everybody steps back and says, okay, it's the law. We're all going to quit fighting about it. We're just going to move forward. So I think in many of these decisions now that are being made about whether states will expand Medicaid, what the exchanges will look like, whether states will run them, all are going to carry a very, very heavy political aspect to that discussion, as opposed to a sort of practical look at this. Is it better that the state has the exchange or the federal government comes in and does it? It will be a very, very politically charged debate. So I think there's going to be, clearly going to continue to be opposition. But on the other hand, I think people ought to all recognize that this is and will be seen as and how the president wants this to be seen as one of the great legacies of his 8 years in office. And so I don't think you're going to see any backing off in any way by the administration on this. You may see, and I hope you will see, some flexibility and some willing to engage in states and some appreciation of the political challenges that some governors and others may have in coming along, and some willingness to make accommodation. And I think we're beginning to see that. Just yesterday, the Secretary said that she would extend the time for states to determine whether they would come onto the exchange. I think that's a signal of a willingness to try to work. But I don't think anybody should mistake an attempted accommodation with any kind of sense that the second term of this administration won't be about full implementation of the law. The political fight has come into sort of two main points right now, and actually this is where the legal issues have led us from the Supreme Court decision. The first is whether or not states will expand their Medicaid. For those states like Wisconsin that are already well above what the minimum standards of the Affordable Care Act, this is not that big of debate. There are some interesting issues for states like Wisconsin, California, about 16 others that have already gone well beyond the Medicaid limits. One of those is actually whether you retract Medicaid coverage and put people into the exchange. But for those states that are well below the 133% line for eligibility, some states, as I understand it, as low as 20, they're 20 or 30% of the federal poverty level for Medicaid eligibility, and they have to expand to 133. That's going to be a very big decision, and I think there's a lot of political, I would say, posturing going on right now. Let me just say that in the history of these kinds of Medicaid expansions, major Medicaid expansions, the S-CHIP expansion, which was the Children's Health Insurance Program expansion, there was, while not as noteworthy and not as politically charged, there was quite a bit of opposition from some states saying that they wouldn't do it. The practical history is that over a period of time, sometimes it takes 4, 5, 6 years, but all states do buy in some form or other. I think that the political pressure or the practical pressure on governors that say that they will not expand is going to be enormous. This isn't money that goes to poor people. This is money that goes to hospitals and providers, and it's going to be very, very hard for those providers to sit and watch the federal money that is available just sit there while they are providing uncompensated care. But we'll see how that plays out in some of those states. The other big area, of course, is the exchanges, and that's the one that in the last couple of days has gotten a lot of attention as a deadline has loomed and as governors have started to make decisions on whether or not they will buy in. It's interesting if you look at the list of those that say they will and those that won't. It's a pretty partisan list, with some exceptions. I think at least as I went down the list, there are 3 Republican governors that have said that they will have a state exchange. There may be only 1 or 2 Democratic governors that say they won't. There's also this potential hybrid, which you may see a number of states going to, that is not really in the law, but that the Department of Health and Human Services has opened up, by which it's a federal exchange that is run in partnership with the states, so the state has some say in its design and in its implementation. There are really big issues about these exchanges, and states that have just sat and done nothing and are way behind, it's hard to see how they're going to be ready for when the open enrollment starts in 2013, even if they wanted. But these are issues that I think for many people on this call and their clients that you may already be dealing with. But these are issues to be at both the federal and the state level. But what is the scope of essential benefits? What does a plan have to have? What is actuarial equivalence? There are really significant issues on what happens with the pooling pressures. The Affordable Care Act is obviously, at its core, it is designed to have a guaranteed issue policy and community rating so that people are all much closer to the average. But what are some of the limits that are going to be put on that? Will there, the age rating What kind of limits on open enrollment? How do you keep people from jumping to one plan to another just depending on how, whether they're sick and they need one plan over another? How do you allow the insurers to have some predictability in who they have and how long they have them as their insureds? There's a big just IT issue largely, but others as well about just the functionality of exchanges. There is a lot of issues that are floating, that are out there right now about as states do not do this and the federal exchange comes in, what is the interaction between a federal exchange that comes in and a state insurance market and the state regulation of insurance? We're going to see some very difficult issues that come around through that. The whole issue of who's eligible, the subsidy determinations, and one that I want to really focus on or mention, but to me really critical, is what is the public education. There's been so much public debate about this. It's going to be very hard, but I think essential that good non-political information gets out to people about what this is and how they enroll and what the benefits are for them to enroll and so on. So those are some of the very big pressures. Let me just to finally say, and I know that Scott and Ted are going to talk about this, but all of this talk about health care and the Affordable Care Act, what sort of looms over all of this, like on everything, is the sequestration, the budget cuts, the grand deal. There is no doubt that in order to long-term balance federal budgets, and certainly for long-term looking at state budgets, that the most rapidly, and in fact, if you look at state budgets over the last 5 years, the only area of cost growth, of expenditure growth in those budgets has been in health care. And so in connection and in many ways related to the Affordable Care Act, but as part of that, there's no doubt there's going to be some kind of cut that is coming. And that really has to be coupled with what we've all been talking about for a long time, which is major payment reform. So ACOs, innovation grants, I think you're going to see a lot of other opportunities as well to find ways to compensate for good health care at lower costs, which is easy to say and very, very difficult to do. And the one final point on that I just want to make that's often overlooked in the whole healthcare debate, but is the sort of sleeping giant from state budgets, is long-term care, which is in most states, over half of the Medicaid benefits go for long-term care. Increasingly large share of Medicare at the federal level goes to long-term care. And we spent a lot of time in the Affordable Care Act talking about how we try to reduce costs in the medical system, but I think the sort of real sleeping giant out there is the whole issue of long-term care, and I think you're going to see a lot of activity in the next couple of years around managed care systems in long-term care and other ways to try to contain costs. So, David, thank you very much. I hope I haven't gone over my time, but there's a lot going on in this area.
Governor, you've done very, very well, and of course this is a topic of great interest. We do have a number of emailed-in questions, but I'm going to send those to you separately so that we can keep moving on our presentation today.
All right. Thank you, David.
Thank you. Our next presentation is by three panelists, Scott Kluge, Ted Bornstein, and Cleta Mitchell. Scott is a public affairs director with Foley, having previously represented the Madison area in Congress for 8 years, and has become an expert in healthcare, insurance, financial services, telecommunications, and energy. Ted is among our most seasoned lobbyists here in Washington, where he oversees the federal lobbying practice for our office and works with our political law team to advise clients on campaign finance matters and Lobbying Disclosure Act issues. And Cleta Mitchell leads our political law practice. She has more than 30 years of experience in law, politics, and policy, and advises corporations, nonprofits, and a host of issue organizations, candidates, and campaigns on compliance with state and federal campaign finance laws, ethics, and lobbying disclosure requirements. And she serves this year as president of the Republican National Lawyers Association. So with that, Scott, Ted, and Cleta, you're on.
I think Cleta's up first. Go ahead, Cleta.
Well, thank you. I'm just going to give a couple of thoughts and overviews, maybe from a little different political perspective than that expressed by the governor. I think that the real issue over the next, remember today was the original deadline for states to advise the Department of Health and Human Services as to whether they were not going to establish the health exchanges that are envisioned in Obamacare. And not many of the states have yet stated whether they are or not going to do that. The Republican Governors Association is meeting right now in Las Vegas. The incoming chairman of the Republican Governors Association is Bobby Jindal, governor of Louisiana, who has announced and written a very compelling letter as to why Louisiana is not going to participate. We have seen other states start to fall in line. I think what you'll see is that particularly in Republican states, that Republican governors who are considering whether or not to establish health exchanges I think there's going to be a lot of political pressure on those governors to not accept the participation and to essentially say, this is to the federal government, this is your program, you do it. I think I can assure you there is a growing, what someone referred to yesterday in a meeting in which I was participating as a resistance, that they're going to choose not to be collaborators but to participate as part of the resistance movement because there is still a great deal of concern about the future direction of our economy as a more status, centralized economy than they are comfortable with philosophically. So I think you're going to see that play out, and that one of the reasons that the deadline was extended for 30 days was because the federal government needs to do some arm twisting to try to get the states to agree to participate. So I guess I would just say overall with the election, I think that a lot of people on my side of the aisle at least believe that this is something of a status quo election, that it was not a mandate for any particular effort one way or the other. And I know Scott and Ted are going to talk about what's going to go on in the lame duck and what we can anticipate next year. I think the most telling thing was the statement yesterday by Richard Trumka, the national labor leader, who essentially says there really is no fiscal cliff, that the CBO's projections about a shrinking economy in 2013 if the Congress doesn't cut spending and do something about the deficit, that's really not true. So I think there's going to be a lot of pressure from both sides politically to hold the line, and I'm not sure anyone on my side of the aisle believes that there was a huge mandate for changing course in terms of philosophy. I think the one issue area where I think that might not be true any longer is in the area of immigration. And I know that there are a number of working groups that have already been established to say, look, we really have to come up with some proposals about immigration that are not so off-putting to Hispanics. So with that, I would turn it over to our seasoned lobbyists, Ted Bornstein and Scott Klug, who can tell you in much more detail what we can anticipate in the Congress.
Ted, do you want to go first?
Sure. As everyone is aware, on December 31st, if Congress has not passed legislation to extend the Bush tax cuts and has not passed legislation to cut spending and address the deficit, automatic things take place, and that is the Bush tax credits expire. The tax cuts expire. There are mandated cuts in defense spending, Medicare spending, domestic spending, and basically we will have fallen over what Federal Reserve Chairman Bernanke calls the fiscal cliff, in which CBO has projected there would be a major shock to the economy that would probably send us into a double-dip recession, but even more seriously would spook the international financial markets and seriously affect the economy of the United States and that of the world. And those are the stakes. At least those are the stakes that most economists believe are at play, and I think most mature political leaders. believe would take place. But it leaves the possibility of three scenarios to take place between now and the end of the year in the lame duck session. One would be a soft landing, which would mean that we reach some sort of grand agreement between now and the end of the year on taxes and spending. I think the chances of actually succeeding at that are very slim. It's very hard to address all those issues in the next 6 weeks. The other would be a very hard landing, which would mean that we would fail to reach any sort of agreement, and sequestration would take place on January 1st, and the tax cuts would expire on January 1st, and we would suffer a shock to the economy, which would then force Congress to respond early next year and do something. And then there's probably the third scenario, which I think is the most likely outcome, and that is we find some sort of down payment on spending. We pass some form of extension of the expiring tax cuts, and we establish a frame. Congress and the President establish a framework for increasing revenues either through tax reform, cutting spending, and starting a process for entitlement reform. And the mechanism for that would be something under the Budget Act called reconciliation, which has been used several times, most notably in 1981 when President Reagan passed budget cuts and tax increases in his first year in office. The next couple, as you've seen over the last few weeks, you saw Trump making a statement yesterday that there is no fiscal cliff. Senator Murray, who was the incoming chairman of the Senate Budget Committee, is saying on National Public Radio this morning that she'd be willing to let us go past the January 1st deadline without addressing these issues if Congress, if the Republicans don't agree to raising taxes on the very wealthy. And I think for the next several weeks, at least 2 weeks, you're going to see a lot of posturing. Congress only got back from the after its election this week. Both Democrats and Republicans in Congress are trying to assess what the election meant, and I think both Boehner and President Obama are trying to figure out where they are with their respective parties. Speaker Boehner is under a lot of pressure from conservatives in the Republican conference in the House to stick to their guns and not raise revenues and certainly not increase the tax rates. President Obama is under pressure from the Democratic caucus in the House, which will be more liberal in this Congress than it was in the last Congress, and will have picked up between 5 and 10 and 11 seats, most of whom are going to be liberals, not moderates, who are going to try to make him hold his feet to the fire. And so right now, I think that both sides are assessing where their strengths are and are in a position of posturing, and we'll get down to serious discussions in the second week in December. Scott?
Yeah, I agree with Ted. If I looked at the roster of who signed into this, we've got lots of folks following sort of narrow issues on health care and investment taxes and all that. So let me, if I can, from sort of a wider perspective, tell you what's at risk just in terms of the tax increases that are coming. The biggest one may be the AMT patch goes away, which essentially means 28 million Americans immediately have their taxes increased pretty dramatically, up to $4,000 a year. And it affects families with income, say $75,000 and 2 kids at home. So it's going to hit pretty hard and pretty fast. A whole series of extensions on individual tax credits, research tax credits, credits for alternative energy, also a fairly significant increase in capital gains. The state taxes go up. For those of you in the healthcare world, the doc fix is pending. Medicare-dependent hospitals is pending. So I think there's enough tax increases out there that there's wide agreement that they have to be extended, that I think there will be some kind of deal. I think the odds of us getting a grand deal done between now and the end of the year are next to none. There's simply not enough time to get done. So let me suggest that I think the most likely scenario is an agreement between President and Congress to do some series of budget cuts and some series of tax increases between now and the end of the year. And I think then essentially rolled over to reach a grander deal on taxes and spending cuts in the spring, which may bring with it a bipartisan effort to lower both corporate and individual tax rates. And as part of that, I think the most likely scenario is essentially Republicans delivering more revenue by eliminating tax loopholes than actually increasing marginal tax rates. And interestingly, the place really to keep your eyes on, which is counterintuitive, may be the Senate, because there's an active group of 6 Republican and Democratic senators, sometimes 8, depending upon who shows up for meetings, that I think are really trying to figure out the outlines for a grander deal. Senator Corker from Tennessee might be in the middle of this. He's talked about, for example, in the last couple of days, taking the Romney idea and putting a $50,000 cap on deductions, which gets you to about $800 billion in new revenue, and essentially gets the $800 billion in tax new revenue that the president wants, but also avoids the increase on marginal tax rates, which I think the Republicans are going to have a hard time giving into in the House. So I think the most likely scenario, as Ted suggested, is we'll be at the brink probably close to Christmas. I think the odds of something getting done that's spectacular are pretty slim in the short run. I think in order to hold the bond markets at bay, they're going to have some kind of firm deadline if the grander deal is going to happen in the spring. So we may have, a fiscal cliff too, sort of aimed at March or April. And I think the risk to the economy is so large that there's going to have to be some kind of agreement before the end of the year because the economy won't take the shock waves and the sort of massive tax increases and spending cuts will have a huge impact on the economy. But hanging out there is the bond market, which is going to force, I think, discipline both in the short run and the long run being between now and next Memorial Day. So that's sort of the scenario we see coming, and I know David's trying to keep the train moving on time. So any individual specific questions you have, feel free to email them on to Ted and Cleta and I, and we'll address them individually.
Well, you all have done so well time-wise. I do have time for a question or two here. One is on a medical device excise tax that I know has gotten a fair amount of attention. It's currently slated to go into effect on January 1st. Have any of you had any indication whether or not that's on the list of those possibly being postponed?
It's on the list, but there are lots and lots of issues on the list, and I think it could well be addressed before the end of the year. I know that there are people who want to do it, but I caution folks that there is a long list of both tax provisions and cuts that are trying to be avoided like an SGR. That's physician payments that are on the must-do list, and whether we reach that, whether we meet the deadline or not by January 1st, it remains to be seen.
Yeah, there's a lot of unresolved issues in here, even in terms of, which devices are sold. So, the devices, for example, include devices used by veterinarians, or is it just human? And is it, retail items like latex gloves, or is it more specific medical equipment? I think a lot of that's unresolved, and I think Ted's right. There's a whole bushel basket full of individual tax incentives and new taxes that people are concerned about, and an extension of existing both tax credits and tax increases. I think that's all going to play out. I think if you listen during the campaign, I met Ryan, who's the chairman of the Budget Committee, and Camp, who's the chairman of the House Ways and Means Committee, are both pretty determined to lower individual and corporate tax rates. For example, because I think they want to see all this corporate income that's stuck offshore, which if it comes into the country gets dramatically taxed. I think they want to figure out some way to have a tax holiday to bring all that cash back so people can invest in plants and invest in hiring new people. And I think we're just not going to know how it will play out. But I think the philosophical bent, at least in the House, and I think even to some degree at the White House, is to figure out a way to close loopholes to lower rates. And I think the president's very conscious of his legacy, and I think one of the things he's going to want to do is accomplish a much larger package. So for the individual issue on medical devices, I don't think we know yet.
And Scott, for you, a political question here. What's the likelihood of letting things go over the cliff January 1, tax rates go up, and then that permits the new Republican Congress to vote for a tax cut, in theory, by virtue of returning it to where it was or something less than what they have vaulted to on January 1? Would that be a politically attractive outcome for the new Republican House?
I don't think so, simply because I think that what's driving this all now is economics, and I think sort of the time for politics is past. I think if we drive over the fiscal cliff, I think there's some polling that suggests the Republicans are likely to get punched in the nose more firmly than the White House will, because the president's done a good job of positioning himself. But I think ultimately the adults are going to rule in this. And again, if what we do is raise taxes and simultaneously cut spending and refuse to deal with this, I think there are some projections now that unemployment could go up over 10%, and the bond market's going to punish the U.S. And if that happens, there'll be higher interest rates on everything, including T-bills, which means higher interest rate for buying houses, which is going to do a great thing to the housing market, which is still stalled. It's going to make it more difficult to buy a car. It's going to have student loan rates go up because the cap won't exist any longer. So I think, and at the end of the day, Obama looks at Boehner, and Boehner looks at Obama and says, I'll get 120 Republicans, you get me 120 Democrats, and let's get this done, because the flanks on both sides aren't going to vote for it.
I agree with that assessment. I think the adults will end up ruling the day.
Very good. Well, with that, let us turn to yet another controversial issue of environmental policy. And for that, we're delighted to have Dick Stoll join us today. Dick is a partner here in our Washington office, where he focuses on environmental law and essentially is a leader of our federal administrative law and litigation practice. He's been repeatedly named as one of the top 25 environmental lawyers in the United States by Legal Media's Best of the Best in the U.S. And since 1989, he's been among the best lawyers in America, and since 2003, recognized by Chambers USA as among America's leading business lawyers. Dick, great to have you with us.
Okay, thank you, David. I'm going to start out by a chart. There it is. I got this off a website last night, and everybody should realize that EPA always has been a regulatory machine, unless there are some dramatic changes in the statutes by Congress. Excuse me, EPA is just a regulatory machine, and that's all there is to it. I got this off the Office of Management Budget website last night. They keep track of, because OMB has to review all major agency rules, and these are basically rules that have $100 million impact on the economy and all that kind of stuff. And you can see, and this is typical, EPA's got a lot more rules under review than any other federal agency right now, and that's very typical. And again, that's the way it's been for several years. That's the way it is right now, and that's the way it's going to be for the next few years. So, and that's whether it's a Republican administration or a Democratic administration. What you have to realize is that EPA's discretion is often very limited by the laws that Congress has passed. And EPA has to issue so many regulations a year, whether it wants to or not, under deadlines, and EPA has to follow certain types of considerations as it issues regulations regarding cost and effectiveness and all that kind of stuff, regardless of which administration is there, because of the laws that Congress has passed. Now, this is unlike what Ted and Cleta and Scott were talking about. What Congress decides to do in the next few weeks or few months, that's not going to affect what EPA is going to be doing in the next few years, I think, unless Congress is going to make some dramatic changes to the organic statutes that EPA administers, like the Air Act, the Water Act, and so forth. And that, as I will discuss a little bit later, seems highly unlikely in the near term. Now, there are some statutes and some parts of some statutes where EPA is given more discretion as to what to do and what not to do, and that's where politics can make a difference. And we have seen major differences in the years past as to whether you have a Bush administration or like an Obama administration. And like, in fact, the title of this presentation, when we start talking about coal, climate, and fracking, coal, climate, and fracking happen to be areas where there has been a major difference in approach going from the Bush administration to the Obama administration, particularly on climate. When you think about climate a minute, the Bush administration did virtually nothing about climate and resisted doing any kind of regulations having to do with climate. And Obama has been all in on that. They tried to get legislation through. They didn't. But they're trying to do everything they can by way of regulation to deal with climate, and we can expect that to continue. And also on fracking, as we'll see in a minute. That's something the Bush people didn't want to touch at all. That's something the Obama people are touching in a big way. So we have seen a sea change with Obama on issues where they do have discretion. And one other thing I should note before we get into the couple of slides I want to show you. I think that the first couple of years that Obama was in and Lisa Jackson was running the agency, we saw time and time again, we saw rules that came out that people were saying, if you're from industry, basically we're showing very little accommodation or concern for economics and jobs and so forth. That did start to change somewhat, and I'm going to talk about this in a minute. That started to change a little bit towards the last year, particularly, of the Obama administration. Maybe it was because the elections are coming up, maybe not. But it did seem to change. So we do have some rules in waiting. You go back to the chart, you see there's a whole bunch of EPA rules sitting at OMB right now. What are the ones that we can expect to come out pretty soon? There's been a lull. For the last few months, because of the elections coming up, I think the Obama EPA decided that unless they actually had an absolute statutory court-ordered deadline to do something, they weren't going to do it if it was the least bit controversial or costly. So there's been some rules bottled up at OMB now for several months that people expect to come out at least pretty soon. I said real soon. Based on something I read today, maybe I shouldn't have said real soon. Maybe I should have said pretty soon. But clearly certain rules have been held up for the election. Industrial boilers under the Clean Air Act is a real big one. We're talking billions and billions of dollars of cost. Everybody agrees with that. EPA's own numbers show billions of costs. We're showing a lot of job losses with those rules once they come out. We're talking about new, very expensive rules on industrial boilers. When you think about it, you got to think most major manufacturing industry around the United States has industrial boilers. So that's a big one. We had expected that maybe EPA would go final on that in the next this month or next month. Gina McCarthy, who's the assistant administrator for air, just said yesterday, though, in a program that it may be, quote, a few months. So that makes one wonder perhaps whether now, even though we have the election lull, maybe now there's going to be a little bit of a fiscal cliff lull. I don't know. I mean, some people, there's different theories on this, but you could now think that perhaps EPA might hesitate to do anything that's really big and bombastic and has billions of costs while there's delicate negotiations going on the Hill that Ted and Scott were talking about. We'll see. But she said a few months now for that rule when a lot of people were thinking that they would try to get it out before Christmas. There are a couple of others, though, that they do have statutory court-ordered deadlines on. There's a very famous rule called the Greenhouse Gas New Source Performance Standard for coal-fired utilities. We do expect to see that go final soon, and that's essentially basically saying no new sources for coal-burning utilities. I mean, that's basically what it says. This is all part of the Greenhouse Gas Climate Program. They have to have a rule out for Portland cement under the AIR Act by December. We expect them to have that. That'll be a major rule. And also a new rule for ambient standards for particulate matter, which will have pretty dramatic effects on controls throughout the United States in the next 2 or 3 years, and that's due out by the end of this year. They also will be having some guidance, so-called guidance on hydraulic fracturing that they were holding back on pending the election. We now expect that to be coming out sometime soon. And this is all of a sudden, again, unlike the Bush administration, this would be a pretty strong federal stamp on what sort of practices constitute safe fracking versus what kind of practices don't constitute safe fracking. Then we have other rules that we think will be coming out, as I said, soon enough. We have a whole bunch of new rules under the Air Act and the Water Act on electric utilities that the EPA is poised to either propose or finalize, especially on coal burning units. Again, people say, and I think it's quite fair to say, that there has been a, quote, war on coal. The war on coal is tied to the firm policy of the Obama EPA to do anything and everything they can to control greenhouse gases. And so if you're going to control greenhouse gases, it makes sense under their theory to do what they can by regulation to discourage the use of coal and even the mining of coal. We can see the second bullet I've got there is I think we can see more EPA controls on greenhouse gases for existing units. So far, they focus mostly on new units in what they've been doing. Although President Obama, again, maybe this is a little bit of a signal of going a little bit slower and a little more accommodation to economics and jobs. President Obama just announced on November 14th in a press conference that he wants to have sort of a long-winded, a long dialogue now with all sorts of interest groups, scientists and engineers and economists and stakeholders from all sorts of positions on greenhouse gas before moving to go after existing sources and before deciding whether to suggest a carbon tax or new legislation on cap and trade or something like that. And the other thing you've got to remember that you're going to see, and again it's because of the statutes that Congress has passed, is we're going to see this never-ending cycle, as I describe it, of new proposed and final rules under the Air Act, the Water Act, RCRA, all these other statutes, because Congress has set deadlines for EPA to act, and there are many more regulations in the pipeline that EPA hasn't issued yet, and Congress has given citizens groups the right to sue EPA in court when they miss those deadlines, and it even gives citizens groups attorney's fees for doing this, and then EPA gets court-ordered deadlines, and this is the way EPA has been saddled with these deadlines for years, and that's not going to change unless Congress does something dramatic to these statutes, which is hardly likely to do. Changes in policy and personnel, I've already mentioned that we've seen some tempering, some sensitivity even before the elections of the Obama administration, which seems to be a little more concerned about accommodating economic and jobs interests. We'll see how that goes. Again, an exception there may be with coal burning and mining. They do seem to have a hard policy on coal burning and mining, and I don't see that changing dramatically at all in the next 4 years. On personnel changes, too early to tell, but it seems like right now the tea leaves are indicating that Lisa Jackson's going to stay for a while at the top. Gina McCarthy may stay there as the Air Assistant Administrator. Recall that Carol Browner stayed all 8 years in the Clinton-Gore administration. What to expect from Congress on this? We've got the Republican House, we've got the Democratic Senate, we've got the Democratic President. What we've seen the last 4 years is that the Republicans keep proposing changes to the laws. They pass bills in the House, and they don't get anywhere in the Senate. That seems to be the way it's going to go for the next 4 years. Maybe a few exceptions, a few little targeted areas like coal ash. If you follow the coal ash issue, there is a bill that has some bipartisan support now that would make sure that EPA can't regulate coal ash as a hazardous waste. We'll see how that goes. And one sleeper that has been mentioned lately in several quarters that surprised me at first was maybe a carbon tax coming out of Congress. It would raise a whole lot of money that Ted and Scott would need for their fiscal cliff resolution. It would raise a heck of a lot of money. But I don't know, there's been a little more cold water thrown on that even in the last couple of days. David, I think that's all I have.
That is. Thank you very much, Dick. We're now going to turn to immigration policy in the second Obama administration, and for that we're pleased to have Alan Seagrave join us, who is of counsel in our immigration, nationality, and consular law practice. Alan is located in Miami, where we have a very, very active immigration and nationality and consular law practice. He's a Florida Bar Board certified immigration and nationality law attorney and regularly advises clients on the entire range of employment and family-based immigration issues. Alan? Well, it sounds as if Alan has not been able to join us. So let us move on. Hopefully Alan will be able to join us, and we'll move on to energy and hopefully loop back with immigration policy in a moment. Next is energy policy issues. And for that, Andrea Chambers, partner here and a member of our energy industry team practice, where she provides regulatory counsel to a host of entities involved in restructuring of the electric and natural gas industries. Andrea, glad to have you with us.
Good morning. Just as background, the Obama energy agenda follows all of the above strategy, which means that they're not focused just on developing oil and gas, but also put a lot of emphasis on wind, solar, nuclear, and biofuels. The policy the Obama administration is to support drilling where it's appropriate, but to recognize that drilling is not a sufficient answer to lower domestic gasoline prices, because they recognize that the largest component of the price of gasoline is oil, or crude oil, which is subject to increasing global demand. So a lot of the policy focuses on increased fuel efficiency standards for cars, use of hybrid and battery-powered vehicles, and also efficiency standards for buildings. Turning to oil supply, one of the issues that was affected by the campaign is the controversial Trans-Canada Keystone XL pipeline, which is developed.
Hey, what do you suggest?
I'm sorry, we're getting some background noise. The oil pipeline is being developed to bring oil sands, crude from Canada to the U.S. to the Gulf of Mexico. It would have easily won approval under the Romney win, since Romney had announced that this was one of his day one goals to approve the pipeline. Some believe that the re-election will not result in approval of the northern leg of the pipeline because of the environmental impacts. There are large protests actually being scheduled for this weekend in Washington, D.C. We also saw Trans-Canada stock drop after the election. Others believe that it will eventually obtain approval. Some of the key debates are the impact of bringing the crude gas from Canada to the U.S. and whether that will actually result in lower prices for domestic supply, or whether that gas will actually go into the external markets. Next slide, please. One of the major focuses of the Obama plan is to develop our abundant supplies of natural gas, and a larger component of the gas that's now being produced is being produced through hydraulic fracturing. One issue that, or one area where we will see some development now that the election has passed is at the Department of Interior, where BLM is proposing its final version of regulations on fracking on federal lands. Here we expect to see increased restrictions for drilling, more rules governing water management, and also some controls over the methane emissions that are increasing as the large increase of gas production is accomplished through fracking. Another significant issue in the gas industry sector is the development of additional liquefied natural gas. Historically, the U.S. has been an importer of LNG, but the prices of gas have decreased significantly in the U.S. due to the increase of supply from fracking. Currently, the gas prices domestically are roughly $2 per million BTU, whereas in Europe the price is around $9 to $10 per million BTU, and in Asia, it's exceeding $15. So there's a large amount of pressure to export. There's some export of natural gas occurring now to free trade countries, but the issue that's become very political is the export of gas to most other countries. The concern of Congress and others in the manufacturing sector is that the export of natural gas into the global markets will force domestic prices to increase. Now that the election is over, we expect DOE to complete its review of the economic impacts of increasing exports of natural gas. And recently, I guess Chris Smith of the Department, the Deputy Assistant of DOE, announced that they expect to release those results this year. Early indications are that due to the studies of the increase in prices domestically due to LNG exports, that there will be caps placed on those exports at various levels. Also, we're expecting different criteria for pending applications being evaluated, such as looking at the project's viability and also the geographic diversity of where the projects are located, rather than just looking at when the project application was filed. Another effect of this increasing use of natural gas and the decreased price of gas is that it's being used increasingly for producing electricity, also because coal plants are being shut down for various concerns with the environmental regulations. So a lot of the production of electric gas in the future, or electricity in the future, is anticipated to be gas-fired, and the Federal Energy Commission is focusing a lot on coordinating gas and electric utility operations to avoid blackouts in the event that there's gas shortages or some weather events. Next slide, please. Lastly, the policy of the president, the president's plan for energy also looks at various innovative ways to increase clean energy production in the future. There's a lot of emphasis on solar and wind. There's some feeling that, or at least there was initial feeling that the Secretary of Energy, Chu, will continue in office, and I know there's a lot of names being floated as his replacement as well, but the wind and solar industry is hoping that he will continue since he's a strong supporter of renewable energy. On the wind, I guess the biggest problem for the wind industry in the last year has been concerns about the expiration of the production tax credit, which was due to expire at 2012. It's now looking very likely that there's a 2-year extension of this tax credit, and also it's effectively a 2-year extension because the plants don't have to be built until, they just have to start construction at the end of 2013. So it's looked at as a 2-year extension. On the solar side, the Obama administration recently announced the roadmap for building large-scale solar plants on public lands. So that's something that's been will help a lot in development of the solar industry. With the increase of emphasis on wind and solar, there's also going to be a need for upgrading and building out the transmission system, and that's because wind and solar resources are usually located very remotely from the major load population centers. So there will be increase in building out transmission to bring those resources into the load centers, and that includes not only onshore but also offshore, where there's a proposal to build a large backbone transmission system along the mid-Atlantic coast to connect those offshore resources to the major cities on the East Coast. One of the other, on transmission, one of the success stories on the Obama administration is what they refer to as the Interagency Rapid Response Team. And it's a plan to advance the permitting of these large-scale transmission developments. And it appears to be having a positive impact based on the first 7 projects that have been through or have been chosen for this IRRT team to look at. Some uncertainties still remain regarding the build-out of the transmission system in the investment community. There's been criticism of the Federal Energy Commission in its lack of consistency of granting incentives for building out these systems and the lower equity returns that have been granted. Also, the FERC process is the process for acting on the request for transmission incentives has been slower than many would like. And that's all I have.
Thank you, Andrea. Now for our participants from New York, New Jersey, let me announce our first course code. It is HIHFT. Again, HIHFT. I'm advised by our conference organizer that Alan has been connected. Alan, are you with us?
Hi, David. I hate to say this, but can you hear me now?
We can hear you perfectly. Thank you for joining us, and we'll now turn to immigration policy with Alan C. Grave.
Thanks for having me, David. Happy to be here. I guess everyone is aware that the recent elections make it clear that the heat is really on for some sort of change to our immigration system. The impact of foreign national communities has had a marked impact on President Obama's reelection, which really seems to be a true change to the political landscape for the prospects for comprehensive immigration reform. We certainly are now seeing Republicans in Congress and even conservative political commentators acknowledging that there's a need for a more humane solution than the so-called self-deportation of undocumented individuals in the United States. In other words, a system that just makes it impossible for them to remain, so they leave on their own. But it's very hard to gauge if this is really a moment for comprehensive immigration reform, because there are a lot of factors that work against a true overhaul of the system. To some extent, it's going to depend on how comprehensive immigration reform is defined going forward by the new Congress. President Obama has recently restated his goals, which I guess would be his definition of comprehensive immigration reform, based on more secure borders, a reliable employment verification system and sanctioning of employers of undocumented workers, the DREAM Act, institution of the DREAM Act, which is a path to permanent residence specifically for undocumented early childhood arrivals in the United States who demonstrate a commitment to education, military service, something of that sort, and also a path to citizenship for undocumented individuals in general, which really seems to be what's going to be the bone of contention for a bipartisan support for true immigration reform. So what is it really? In the past, it was more than those four items that President Obama has identified. It really means a systematic overhaul of our immigration laws that focuses on building real checks and balances into the immigration framework that we use. These immigration laws that we have, if you're not familiar with them, really have been identified as some of the most complex and at the same time archaic provisions that can be found in the United States laws, dating back in large part to the Immigration and Nationality Act of 1952. And they really have confusing and sometimes absurd consequences when they're applied as they are. So really what we're talking about is something that goes beyond those four factors that President Obama has signaled are his priorities. Truly, comprehensive immigration reform would need to address, yes, border security, but also situations such as improving conditions of detention of people that are subject to removal from the United States, increased protection during enforcement, yes, verifying employment authorization, but in some sort of equitable way. And the other area that really needs to be addressed, and it's somewhat unfortunate that President Obama hasn't mentioned it, is the backlog and the unavailability of visas, both in the family and in the employment-based categories. Of course, one of the tenets of our immigration system is family unity, and we've really seen that go by the wayside over the last couple of decades because we do have, in effect, quota systems in the United States for visas, not based on nationality, but by visa category. And this has led to all kinds of separation of family members and the inability of really the best and the brightest to find a means to immigrate easily to the United States because of limitations on visas for employment from top to bottom, from unskilled to the most highly skilled workers. So those are aspects that make the prospect of comprehensive immigration reform really a daunting task for the Congress. What's been happening lately since the election, most recently, we've, of course, seen discussions coming about between Senator Schumer and Graham talking about the prospects for comprehensive immigration reform, but right off the bat, the issue becomes if there won't be a path to citizenship for undocumented workers until there's a plan to truly secure the borders. How that's going to be accomplished is really difficult to say. Also, recently, there seems to be some interest in the House to try to present some sort of high-tech visa bill during the lame duck session to see if there's any way that bipartisanship on this issue may fly. This same bill came up in September under the suspension of rules but didn't clear the House, and it really is geared to lawful permanent resident status for university graduates with advanced degrees in science, technology, engineering, mathematics, that sort of thing. It would eliminate some other types of visas, such as the diversity lottery, and therefore free up more numbers dedicated to this type of visa. Along those lines, the discussion regarding that particular high-tech visa bill has been an effort to reach some bipartisan conclusion where these 55,000 visa numbers would be split between high-tech jobs and family reunification visas. So again, that seems to show what the priorities are going to be going forward, and that there's still going to be a lot of give and take on really how comprehensive immigration reform is going to look, notwithstanding the mandate to go forward with some sort of reform. I mean, in the least, it would appear that something's going to be happening, whether it's this true comprehensive reform or a piecemeal fixes to some of the more pressing issues in immigration. Very hard to say. There's certainly an easier ability to approach it on a piecemeal basis. There are some easy fixes to some of these pressing problems. There are laws that have sunset that could be reinstated to help for family reunification, some of the most difficult cases. And again, who knows what comprehensive immigration reform might mean. The last major overhaul was the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. That did, unfortunately, create some of the more draconian aspects of immigration that we're dealing with now with regards to deportation and removal from the United States that are now becoming seen as inequitable and certainly are not going to be popular with communities and community activists that are very involved with immigration. So by the same token, as has happened up till now, President Obama had some success through agency rule changes to favor some immigrants that were in difficult situations. This deferred action for childhood arrivals is a precursor to the DREAM Act, where educated children that came to the United States with their parents do have some sort of a path to legal status, although the way it is on the rules is very limited. Also, there have been inroads in prosecutorial discretion to prevent removals of non-criminal aliens from the United States. So I would expect that those are going to continue to be priorities, and there is a lot of room in the agency rules to make rules more equitable or more acceptable to immigrant communities that may be a way to go if there's no way to get legislation passed. So, David, that's all from here.
Thank you, Alan. Well done.
David, this is Howard Floats. I just wanted to let you know I joined.
Wonderful. We'll be with you in just a minute, Howard. Thank you.
Okay. Thank you.
Before we do our next presentation, let me repeat again the course code. Hotel India Hotel Foxtrot Tango in phonetic, HIHFT, Hotel India Hotel Foxtrot Tango.
David, it also sounds like all the speakers ought to be on mute right now. We've got some interference coming from somewhere. At least I'm hearing it.
I am as well. Howard, that may be from yours. Good. All right. Thank you. Our next topic is intellectual property, and it's an issue that most, I think, thought had been resolved in the American Invents Act, but it is very much back on the plate in the lame duck Congress, potentially as part of omnibus legislation. And for that, we have Matt Smith, who is a Foley partner here in our Washington office, where he serves as chair of the firm's Patent Office Trials Group and a member of the IP Litigation Group. He focuses his practice on patent disputes, particularly those involving complex USPTO aspects, and he's advised clients on numerous litigations and more than 80 patent reexamination proceedings. Matt, good to have you with us.
Thank you very much, David. We're going to give Alan a run for his money on the most archaic set of laws in the federal code. Of course, we're talking about patents, and in 2011, as David mentioned, we had the most comprehensive patent legislation in 50 years in the form of the America Invents Act. And as surprising as it may seem, it does take some time and momentum to get Congress interested in patent reform. It's been in a bit more vogue in recent years, probably because of the dawning awareness that we have, at least from the perspective of our position in the international economy on a competitive basis, that the United States is transitioning to more of an innovation-based economy. We saw patent reform bills that didn't make it through Congress in 2005, 2006, et cetera, all the way through to 2010 until ultimate passage of the America Invents Act in 2011. And there was really intense lobbying surrounding all of those bills. And the sides in patent legislation really don't divide along party lines. It's just too abstract in some ways to fall neatly into the typical ideologies or to be communicated quickly to constituent bases. What we do see are commercial interests, essentially for and against patent protection for one reason or another. Against patent protection tend to be consumer electronics and software companies, even some very innovative ones, as well as companies that themselves don't invest a lot in innovation. And on the pro-patent side, we typically have university groups who are doing a lot of the upstream research. We have independent inventor organizations. We have brand name pharmaceutical companies typically, as well as some select electronics-oriented companies that are really founded on innovation. So now we're in the wake of that major 2011 effort, and Congress is sick of patent reform. The less vehement of the pro and anti-patent activists are tired. They spent a lot of money on lobbying. And, of course, we have the lame duck session coming up. So where does that leave us? So I think the first thing to mention as topical in this entire webinar is that the second term of the Obama administration really has less to do with where patent law is heading than it does in some of the other areas. One very good thing about it is that the current Patent Office administration will not be forced to leave. Director Kapos and Deputy Director Ray have been doing a great job. Hopefully they can stay where they are. That's not to say that their replacements would have been bad, but these are hard jobs, and it's good to keep good people. Legislatively, we're really more focused on the state of Congress, having just spent their energies on a major reform effort, but also having a little bit more freedom post-election to get some things done. So there are really two things going on in Congress right now. First, there's an effort to ratify some international treaties, including the Hague Convention on International Designs. And frankly, these efforts are really not that interesting. If you look at the treaties, they're very procedural. They don't really touch on any important interests. So in all likelihood, they're going to pass, and they're really not going to mean much. So hopefully at least knowing that is valuable to the people listening. The second thing that's happening is the lobbying that's going on surrounding the so-called technical amendments. And these are amendments that are passed after a major piece of legislation to correct some mistakes in the legislation. And, you know, they're really premised on the idea that these are things that everybody would recognize as a flaw. So you don't have to have a real partisan discussion about it. And despite the safeguards that are in place, any major legislative effort is going to have these kinds of mistakes. And they typically reveal themselves a little bit later when people actually try to comply with the law, when you see how the law interacts with other regulatory and legislative regimes, and when you see how the law influences commercial practices as they are on the ground. And some of these things are very hard to predict when you're drafting the law. It may be that, you know, some of them are too controversial to really take care of in the first go-around. So there are a few issues in the technical amendments that are of interest, and I'll basically discuss two of them. The first relates to what actually qualifies for patenting. Of course, you can't patent things that people have already come up with. That's not what we call invention. An invention should be the first time it's done. And in some cases, you can't even patent what you yourself have already done secretly if you've been using it commercially for a period of time, and that period currently being 1 year. And the concern behind this rule is that it's not fair to allow someone to come up with an invention, to use it commercially in secret for a while, and then later file for a patent and get a monopoly on that invention. One of the motivating theories behind the existence of patents is to say, okay, if you come up with some good technology, disclose that to the world so that everyone has the benefit of it, and we, the government, will give you a monopoly on it for a limited period of time. And so if you allow someone to essentially exploit an invention commercially for some period of time and then to get a patent monopoly on it later, you are effectively extending the term of that monopoly. So the law prior to the 2011 change was pretty clear. You had to choose early on, keep it a secret or patent it. The America Invents Act in 2011 changed a lot of things, but it wasn't actually clear whether this particular rule, which has been in place for probably 80 years, was changed or not. So in other words, you didn't know after the implementation of the America Invents Act whether people could patent things they had already used in secret commercially for some time. Now, the Patent Office has since taken the position that the America Invents Act did, in fact, overrule this prior policy. So now one of the main questions will be whether the Patent Office's interpretation is correct or whether it needs to be clarified in some way. And that could potentially take the form of changing the statute or perhaps congressional records saying the statute is clear as it is. And generally, people who don't like patents want to keep the old rule, and people who do like patents don't want to keep the old rule. So that's the battleground coming up for that particular provision. The second lobbying effort that I want to talk about relates to the ability to challenge patents that are invalid. An invalid patent occurs when the patent office grants a patent on an application concerning an invention, but should not have. And they should not have because, in fact, somebody prior to the applicant came up with the same thing, in effect, or something so close that it doesn't really matter. In that case, the patent would be considered to be invalid. Now, you can always challenge a patent as invalid in court. So if the owner of a patent comes to you and says you are infringing the patent, as a defense, you can come back and say that patent is invalid because so-and-so did it 2 years prior to you. In the America Invents Act, there were created some new or maybe just revised but significantly different procedures to challenge patents as invalid. Those challenges happen before the patent office, not in court, and they're really powerful. So if you like patents, you don't like the new procedures, and if you don't like patents, you do like the new procedures. Now, in theory, the ability to challenge a patent before the patent office and in court would give people the chance to challenge the validity of the patent twice. So if you lose in one place, you can go to the other place and challenge the patent again. You get sort of 2 bites of the apple. And that seems unfair to some people. So to address that, the America Invents Act created a rule, which is called estoppel, which prevents people from challenging a patent before the patent office and then going back to court and challenging the patent based on the same arguments. Now, what does the same arguments mean? And that's really where the lobbying effort is right now. The America Invents Act excludes a challenge in court on any argument that you reasonably could have raised in the patent office. So not only the same arguments that you actually did make to the patent office to advance the invalidity of the patent, but anything you reasonably should have thought of at the time, but you didn't actually say to the patent office. One of the efforts that is in place or in motion right now is to eliminate this reasonably could have raised. So that would limit this rule to only arguments that you actually did make before the patent office. So if you had 2 good arguments as to the invalidity of the patent, you could make one before the patent office, and you could go back to court and make a different argument. That effort, I think, is probably not likely to pass. And that's because some fairly influential voices have come out recently saying this is not a technical correction. It's actually a substantive change that sort of alters the balance of power that was essentially put in place with this major patent reform effort that came through in 2011. So I think the first issue, what is subject to patenting, has some chance of being corrected in the lame duck session. But the second issue, in terms of how you challenge patents before the patent office, is probably going to stay the same. So that's a summary of what's going on in the patent field. So David, back to you.
Pat, thank you very much. Our next topic is labor issues. Obviously, the re-election of the president was a significant victory for his union supporters. And we've asked Mark Newberger, who is of counsel and a member of the firm's labor and employment practice, as well as our senior living and healthcare industry team, to address employment and labor issues going forward in the second Obama administration. Mark advises clients on essentially all areas of labor and employment matters, and we're delighted to have him join us today. Mark?
Thank you very much. As you see from the slide that I threw up, that the organized labor movement is very much claiming credit for the victory that Obama received in the election. A recent study based on exit polling conducted by the AFL-CIO claims that 70% of union members in Ohio backed the president, and that nationwide 65% of union members supported Obama. Organized labor is claiming credit for wins in Ohio, Nevada, Pennsylvania. I left off Wisconsin, Florida. And in fact, if you go on the websites of the AFL-CIO and most of the major unions, they're claiming credit for all the states in which he won. And there's no doubt that the turnout the vote effort helped Obama get elected in key states that pushed him over the top from an electoral college point of view. And therefore, organized labor very much wants payback for their effort. Counterbalancing this movement to help get the president elected are the realities of organized labor in America. In 2012, 6.9% of the private sector workplace is organized by a labor union. That's the lowest rate of unionization in the private sector in about 100 years. In the public sector, unionization rates are significantly higher, but they too are on the decline by virtue of the fact that they've been under attack through various states, public sector unionization being something that is regulated by state law, not federal law. As a result, it's pretty obvious that, at least in the private sector, major unionization is on its death throes, and they are looking for the ability to survive in a meaningful way. And so the payback that they want the most is something called the Employee Free Choice Act, or card check legislation, something that had been kicking around in Congress for over 20 years and was hoped that in the first term of the Obama administration, and especially in the first 2 years when the Democrats controlled both the Senate and the House, that they would get their payback then. They did not. And it's my prediction that no matter what happens in the midterm elections in 2014, the Employee Free Choice Act is not going to get passed in Congress because, as we've seen historically, a number of Democratic senators and Congress people from conservative states simply won't back it. So they will not get the thing that they want the most. Richard Trumka this week has again stated that they will get employee free choice in the second term some way, somehow. Honestly, I just don't think it's going to happen. So Obama's in a bit of a jam, and he needs to give organized labor the payback that they're looking for. What you will see, in my opinion, is a lot of optics. This week, the president held meetings in planning for the cliff negotiations, and he did them sequentially. And who went first? On Wednesday, organized labor and social organizing groups met with the president. On Thursday, it was business leaders, and today I believe it's the Republicans in Congress. You're going to see a lot of optics where Obama tries to give the bully pulpit to organized labor, but I don't think it's going to be successful in terms of resulting in immediate payback, in terms of immediate ability to organize new members. Now, if you've listened to the radio in the last day or two, the United Food and Commercial Workers is trying to organize a multi-state walkout against Walmart on Black Friday. That will be interesting to see if that happens. If that fails miserably, I think that's another nail in the coffin of organized labor. Can we go to the next slide, please? In looking at what impact the second term will have on the actual law of the workplace, it's important to keep something in mind, that the president has no direct impact on the day-to-day operations of both the Equal Employment Opportunity Commission and the NLRB. These are independent regulatory commissions governed by a board independent of the direct control of the president. The president does have the ability to appoint these members subject to the advice and consent of the Senate. On both the EEOC and the NLRB, currently they are tipped towards a pro-labor or pro-employee balance of 3-2. That historically has been the case, and that will continue. But in terms of day-to-day decisions that come out of these agencies, the president really has no direct impact. What the president does have the direct ability to do is issue executive orders. And in the early days of the first term, we saw Obama issue executive orders designed to enhance unionization in publicly funded construction projects, where he mandated that project labor agreements be in place. These are contracts among different unions on a big construction site. I think you'll continue to see the president try through executive order to help out his friends in organized labor, but that he may be limited. One of the ways to see if this works and what happens, I think, is when we look at the infrastructure rebuilding that's going to go on in the Northeast as a result of Superstorm Sandy. It'll be interesting to see if those funds are tied to unionization, and I've been dreaming of the day where the federal government through the president tells New Jersey, we'll give you all this rebuilding money, but it's all got to be through union labor, and will that set up a conflict between Governor Christie and the president? I don't know that they'll be hugging after that executive order. Now, what the president does have the direct impact is over his cabinet agency, the Department of Labor. I'm really glad Dick put up that slide earlier of government agencies that were proposing regulations, because if you looked on that, although EPA was number 1, the Department of Labor is number 4. And the Department of Labor is an area where all workplaces, I believe, are going to be impacted by the influence of the president and his appointees. First off, all indications at this point in time are that Hilda Solis, the current Secretary of Labor, is going to remain in place. She is a friend of organized labor. Pending currently in the Department of Labor are regulations in each of the sub-agencies that I've listed, the Wage and Hour Bureau, the Occupational Safety and Health Administration, the Office of Federal Contract Compliance, which regulates affirmative action for government contractors, and the little-known OLMS, which regulates union activity. There are regulations pending that would hold that people like myself, labor and employment lawyers who provide advice to clients on how to resist unions, would now have to do filings and register with the Department of Labor the way persuaders do. Persuaders are people that are paid to talk to workers in terms of keeping unions out. So I think we will see increased regulatory emphasis in wage hour. This is a hot area. I think through that you will see, through that and through affirmative action, you will see increased emphasis to try to deal with the wage disparity issue between males and females as a follow-up to the Lilly-Ledbetter Act. There's a lot of things that can be done through regulation. OSHA will have stepped up enforcement of the workplace. There are a number of workplace safety initiatives that have been pending. And as we look at affirmative action, I think I want to leave the audience with this point. Many of you may know that currently before the U.S. Supreme Court is a case dealing with affirmative action involving admissions to the University of Texas. I just went to a seminar the other evening where I heard Jeffrey Toobin, the CNN commentator, and he's convinced that the Supreme Court will strike down that affirmative action. If that is true, that is not going to have any impact whatsoever on the Office of Federal Contract Compliance. That affirmative action mandate is through the result of an executive order issued by Lyndon Johnson. It mandates that government contractors and first-tier subcontractors engage in affirmative action, and whether or not the Supreme Court strikes down college admissions is not going to change the tide. And I think if they do strike it down, in fact, that will cause the administration to kick back even further, and you'll see a greater push for more affirmative action regulation. Pending right now are, for the first time, proposals to have goals and timetables for the hiring of the disabled and the veterans. That's a big expansion because currently now contractors only have to set goals and timetables for minorities and females, and nobody's against hiring veterans and nobody's against hiring the disabled. So I think you're going to see through regulatory impact an actual expansion of affirmative action regardless of what the Supreme Court does. That's it for me.
Mark, thank you. I don't think there is any doubt in our listeners' mind that you represent the management side of labor negotiations. Our last topic is antitrust issues, and for that, Howard Fote, a partner in our Washington office and a member of our firm's antitrust and international practice group, had planned to speak. Howard, however, is currently on a train headed to Paris, and he's been trying to connect in, and he's advised me by email that his connection hasn't worked. Howard, by any chance have you been able to join us? Hearing not, he's offered to send slides on these issues to our attendees, so we will have those from Howard, and we'll distribute those after our conference. That concludes our webinar today. Let me give you the second course code for those from New York and New Jersey. It's EO1WO, again, EO1WO. I'll repeat that again phonetically. Echo, Oscar, 1, Whiskey, Oscar. Echo, Oscar, 1, Roman numeral 1, Whiskey, Oscar. And again, the first course code was HIHFT, Hotel, India, Hotel, Foxtrot, Tango. We had a request for how our slides can be printed, and again, a copy of the slides can be obtained by clicking on the printer icon on the bottom right hand of your live meeting screen. And with that, we would ask you to complete the evaluation form, a survey that you see on your screen, and we greatly appreciate your attendance here today and hope that you found this to be a productive webinar. Thank you.